there's some question and ambiguity if authorized means the time when you're supposed to start looking for the placement or the time when you actually effectuate the placement. So the application of 156, I think, is unclear, although everyone's assume it applies. But even assuming it did apply, it would not affect this case. And that is simply because when we go past the allegations, the actual facts, the Department of Health Services has been looking for a placement for Mr. McGee in accordance with the supervised release plan signed, or the request for a supervised release plan signed last June. They have looked in municipalities with and without ordinances. What Act 156 did is it took away the shadow of the hodgepodge groups of ordinances that existed all over the state and replaced it with a single statewide standard. The placement, and the evidence would show this, the placement in Wheatland pre-Act 156 would have been specifically blocked by Wheatland's 2,500-foot protected areas. That was a placement that was available, but not appropriate under pre-Act 156 law. This placement was actually made under Act 156 law, in that when you took away Wheatland's ordinance per the statute, it became an available placement. Act 156 actually made this placement available to the court. It would not have, the house existed and it was available for rent, but it was prohibited for use by Wheatland's ordinance, and the department could not go forward with it. However, post-Act 156, taking away the Wheatland ordinance makes it a house that's at least eligible for consideration. So in terms of the application of 156 to that law, this residence actually is the exact type of residence that the legislature intended when they wiped out these buffer zones established by municipalities and applied a statewide standard. Does good cause exist? Yes. And the reason the good cause exists under either the old pre-156 or post-156 standard is because the department continued to look for properties under 156 pre and post in Racine County, and they continue to look for them today, as well as all over the state. This is not a unique situation to Wheatland. I know it's very close to home to them, but what we did is we unified under 156 the standards for placement statewide. This one house in Wheatland happened to meet the criteria, and we can argue about the actual appropriateness of placement separately. But in terms of the house itself being eligible for placement, good cause did exist because they couldn't find a placement under pre or post 156. So I think it's pretty straightforward.